On.
I'm
Thank you.
gonna try.
Yeah.
Can you hear me well? Yeah? Okay. So you know my name already, and you know that I work for Qualcomm. And in fact, I've been asked to replace my colleague Dan Ermely, that you might know. So he decided this very complicated title that I'm not going to try to pronounce, but it's very, very long. So about my background, I'm not an IP lawyer. I studied law and I studied political science, and I'm what we call a lobbyist here in Brussels. So on my daily job, what I do is that I do my best to promote and protect the whole IP family, in fact. So it goes from patent to trademark to trade secrets. I'm the vice chair of the AmCham IP committee, for instance. But for Qualcomm, I would say that my main, objective is to protect and promote standard essential patent. So today I will be speaking in my personal capacity, and I will share some experience that I'm confronted on a daily basis. So about this title, I have decided to touch some of the topic, but not all of them, because I think that if we really would like to touch all the topic covering this long title, I might need 1 week. And it's true. So who we are and what our licensing system. So I have decided not to present any chart, but just to tell you that Qualcomm is now, this is how we want to call ourselves. We are the reason why you love your smartphone. On top of that, so billion, maybe trillion of time a day, people around the world touch something made better by Qualcomm, and we are very proud of it. So we've been in the wireless industry for roughly now 30 years. We are made up, and this is like rough range, but 35% of the employees of Qualcomm are engineers, and we are roughly 30,000 across the world now. But it's not just engineers. We've got scientists, business strategists, lawyers, and government affairs people like me. And we have one goal all together, and it's invent mobile technology breakthrough. So we've been very involved in anything regarding wireless and smartphone and tablets, and now we are entering amongst many players in the IoT, so this is the Internet of Things, and as well we are very involved in the development of 5G technology. Have you heard about 5G technology? Just to make sure that, yeah, okay, I see people nodding. I know you have. The business model of Qualcomm, in fact, it's important to follow what I'm going to tell you after that. But so what is important is that our R&D, so our R&D is essentially developed for others. And we are very few to do that. And so we contribute most of our important invention to standardization. And we are talking about solving massively complex technical problems. And this is done by our engineers and engineers from other companies. So we really work as a collective group. And by sharing our technology and our knowledge, we foster the growth and competition of the whole mobile market. So there is nothing that we just keep for us. Everything is for the whole ecosystem to build on. So our business model is based on 3 key pillars. The first one is invent, the second one is share, the third one is collaborate. For your information, we are one of the largest European Patent Office applicants, and we are still among the top 10. I'm checking every year, so we're still on the top 10, which is very important for us. And this is significant because we contribute technology to standard, and when we do that, this is public. So we need to make sure that this is protected, otherwise this is too late. And patent protection is absolutely essential for us, because that's the way for us to get a return, or to expect to get a return on investment, because not because you're going to have a patent that of course you're going to get a return, but you can foresee that you might get a return at some point. Without that, the billion we spend in R&D would be for free. And this is not something that our investors or shareholders would like. So I have a question for the audience, so this way I can have just a bit of drink. But do you know what is a standard essential patent? Yeah, you can say, yeah. Okay, you know, so, okay.
It's a patent that by definition, let me put it in a negative way, has to be infringed if you want to implement a standard in your products.
That's correct. So in the positive way, it's a legal right that covers a technology essential to the implementation of a standard. So someone from the audience told me, oh, if your patent has a special name, it must be very important. And I like that. I think it's quite interesting, to see the perception. And so what we look at, with standard essential patent as well, is that the high performance and interoperability as well. Those are the key features that our engineers are following. And so in most of the standards body that we participate, there are some IPR policy rules set out to define the rule of the games. And those rules specify that you must get a FRAND commitment. And I'm going to explain what it is. But basically, if you enter in this group and you're going to share your technology, if your engineer have the feeling that this is going to be very, very important, they must send a signal to the group and so to the market. If you don't do that, it could be perceived, and in fact it is perceived by regulator as an ambush. So it's very important, and as well, all those people know each other. It's very important that you respect the rule of the game. And this is what we call, in fact, the FRAND commitment. And in most of the organization that we are participating, we commit to the FRAND commitment. So if you have to summarize, if you have a standard essential patent and you have given a FRAND commitment, it means, in fact, that you cannot exclude anyone. So it's a kind of an exception to, this negative right in the patent system that you can exclude. When you have an SEP, you cannot exclude anybody. Neither your competitor, no one, okay? So anyone who would like to use your technology can use your technology. There is an access to the technology. I just want to, repeat that because it's kind of slightly different from many, many industries. And you know that the right to exclude is one of the key features of the patent system. So what is FRAND? Well, simply FRAND is a contract. It stands for fair, reasonable, and non-discriminatory. And just to picture it, it creates a balance of interest that the implementer, so the user of the technology, will have access, as I explained already, have access to the technology on some fair terms. And on the other side, the inventor will receive a fair return from the investment for developing and contributing the technology. So it seeks to protect, I would say, both sides, and the parties. So it's a contract, and it's enforceable. You can picture it, in fact, more like as a process. And recently, two bodies, like the SENS-ELEC, the European standardization body for the national member states, developed a position paper explaining that, and the Joint Research Center for the European Commission as well. There is a case called the Huawei ZTE case from the European Court of Justice, which has developed a whole, I would say, framework regarding FRAND. It's very important because it gave clear guidance to the industry in terms of licensing negotiation. So two takeaways, an important principle from the Huawei ZTE, according to me. So FRAND is a two-way street, imposing binding good faith obligation on both parties. I'm reading because I know that I've got lawyers around me. So, and the nature of FRAND commitment is procedural and not distributional. So I repeat, procedural and not distributional. So the court has set out some basic negotiation steps to national courts. And now we are seeing more and more, in fact, decisions implementing the Huawei ZTE framework. And this is, I would say, only when there is a dispute. Of course, when there is no dispute, well, they don't have to implement it. But we see, in fact, that most of every players now in the industry, and not just in Europe, are just following the principle from the court. So unlike other jurisdictions, like in the US, for instance, where court seeks to establish a FRAND rate, the European Court saw FRAND as a committee device designed to promote good faith negotiation between patent owners and prospective licenses. And the concept, in fact, is getting now a lot of traction from policymakers across the world. I would like to spend some time to explain you I would say the roadmap of the European Commission on FRAND and SCPs, because the European Commission is working on that. And there are some clear signals from the European Commission, and then I will touch on two of these signals. So what the Commission wants to do is mapping of valuation methodology for FRAND, and those differentiation according to use case of the implemented technologies, clarifying licensing right along production chain, as well touch upon patent pool and FRAND process. Very ambitious. I forgot to mention that the role of the European Commission is to develop some policy guidance with the take-up of the IoT and 5G technology. So it's really like forward-looking and how to help to, I wouldn't say give guidance to the market, but give signal to the market and as well invite more players to talk to each other. So about the freedom to operate. What has happened so far in the smartphone industry, and you touch it a little bit, you know, some aspect of it, but just more to go on the valuation. So in the smartphone industry, the royalties for smartphone so far are based on the final price of the product. This has been the industry practice for roughly 20 years ago. Why? Many people are asking this question right now. Well, I can tell you why from our perspective, my perspective, because so far it has been the most efficient way in terms of the rollout of the technology, because basically anybody can use the technology, and as well it avoids double dipping. So industry has decided this point in the market. And as well, there is a technical aspect of this choice in that most of the SCPs, it's not all of them, but most of them are system patents. So it's not like one patent related to one specific part of the smartphone, but those are system patents. So they relate to the chip, they relate to the antenna, they relate as well to the base station, most of them. And that's why it has been decided to calculate the royalty based on the end price of the product. Now, with the take-up of new technologies and with the IoT, there are a number of questions posed, especially by other industry, not used to discuss and deal, I would say, with the ICT telecom industry. And you know, it's like when you don't know someone, you don't really want to apply the rule. It's just like basic nature. It's better to say, you know, I'm French, so we used to say the French people, yeah, let's speak French and everybody's going to follow. You know, we managed to do that for a couple of years, a long time ago, but that's not the way forward. But so you have this kind of tension on the market. Okay, my model is better than your model. And this is what is happening right now. So with the development of IoT, you have some industry players saying, yeah, you know, your model, we don't really like it. I understand. So now, I think that what is important is to see that in the coming years, we will have more and more products. So I just named some of them, but we could have, well, maybe we have some already. Fridge connected, smart grid connected, airplanes connected, cars connected. We hear a lot of tests in Europe. So the question is, how are we going to price that? I would say as an industry, okay? So the Commission as well in this communication is working on some guidance. And I just want to take two takeaways from the framework that the Commission is following. The Commission, and this is public, so you can find that, because we haven't seen the text, but so far the Commission has said that the Commission will focus on licensing process condition, non-prescribing an outcome. So basically there will not be any magic number for anything. And as well, it's very important to preserve flexibility for evolving business model and technology environment. This is, to me, very, very key, because there is awareness that it's very important for everybody to be able to operate and to decide what could be the best business case. And there is no answer at this stage. So in terms of methodology, I'm not going to do some math, but I thought that I'm going to skip that, but we can go back after. And now I'm too fast, so I'm gonna stay here, but I'm not going to talk about that. So on some methodology, I have listed several options that we have right now for the industry. It's not related to that, so this is disturbing for you. I'm going to go back on this one. So I have listed 7. You might have ideas on additional one, but this is to explain where we are right now in the industry. So you could decide that you could do ex post. And this is, in fact, what I already described for the ICT and telecom industry. So the royalty are based on end-user price. This is what's happening right now. And basically, if you want to picture that, this is what the HC has decided to do in the IPR policy. You could do ex ante as well. So basically, you send a signal to the market. A company recently, like Ericsson, for instance, has decided to publish their rate for 5G technology. If I'm not mistaken, what I read is it could be $5 or $2.5, depending on some circumstances. Option 3 could be price differentiation. So depending on the use of technology, you could decide that there will be one price for, let's say, automakers and one price for smart grid. There is a new body called Avanci, which is trying to tackle this issue right now. It's kind of a marketplace. You can picture it as a patent pool, but basically they are inviting SCP owners to come and offer the SCP for one price, and then you will have other people needing the technology that will just enter the market. They haven't published the price yet, but I understand that it will be soon. So it gives as well another tentative to do that. You could have as well other option, like develop it some code of conduct, saying as well to the market, okay, we're not going to say this price, but we're going to follow those principles in order to define the value of the technology for your product. And I know that some companies are working on that. You could have as well simply like a one-stop shop saying, okay, we don't know, but we're going to convene everybody. And then it will be like one-stop shop, you enter, and then we will help you to meet other people. I think Nokia is working on something like that. There are more, so 2 more, and after I will stop with all the valuation. And you could have something different. So instead of the positive, you could go on the negative, saying, whatever you're going to value the technology, it cannot be this, for some reason. And you could take the example, and this is where I've got my slide. You could take the example, for instance, of all the court decisions that we are having right now, especially in Germany, but as well Netherlands, I think Italy, Romania, following the guidance of the Huawei ZTE and explaining, in fact, what is FRAND and what is not FRAND, and you can draw some conclusion. On this slide, in fact, there is a link where my company and other companies are collecting all the court decisions in Europe following the Huawei ZTE. It's only summary, okay, because sometimes it's very difficult to get access to this decision. But the purpose is to build a database and repository for anybody. So it's not legal advice, it's just summary of court decision. But that can help you as well to define what could be a price or what could be a bad behavior. Option 7, that's all the other theories, I would say, or fabricated theories to erode patent right. I'm just going to name some of them. You might read some article about them, or if you do a bit of policy, you might have heard about it. But this is important as well because this has an influence on policymakers. The main idea basically is to push royalty down to 0. So you have the smaller sellable component, the discrimination of use, meaning that the price should be the same, close to 0, either you use a smart grid or you use a wireless connected TV that needs to ask connectivity all the time. You could have as well just basically asking for compulsory licensing, that's an easy one. Or as well, you have some big companies right now putting a new concept called, okay, whatever you ask in the royalties, you need to exclude the return on investment in the price, and if you don't do that, I will not pay royalties until this is tested in court. So this creates more and more abuse of litigation. So I'm not going to comment more than what I did already, but I would like just you to ask yourself the question, why companies investing billions of euros and US dollars in taking a lot of risks in standardization, and this, help the whole ecosystem, will accept to give their technology for free. As a conclusion, this is a picture of the European Parliament. I wanted to finish with a positive note. So, and just to try to answer to the question from Dan, what makes an equitable, effective, and enforceable licensing methodology around FRAND principle? I managed to say it, my answer is straightforward. Number one, a policy framework that is flexible enough to encourage investment. And number two, an ecosystem that is confident enough for bilateral negotiation. The European Parliament last month adopted, I would say, a positive signal regarding all the players on the market. It's not published yet, but it will be soon. And basically saying that whatever policymakers do, they need to respect the balance of interests of both sides. And the Parliament is of the opinion that compensation to the developer of standard essential patents need to be based on fair, proportionate, and non-discriminatory terms, and transparent, reasonable, predictable, and sustainable royalty rates. That's very ambitious. To me, that's the way forward. Thank you for your time, and I'm happy to take any question. I hope I was not too long.
No, thank you. Thank you, Audrey. I think this is not an easy topic, and to cover it within 15 minutes, it's like really a victory.
Thank you.
So I would open the floor if you have some questions.
Okay, I have one question. As you know, Qualcomm had some antitrust issues in various places. For example, China imposed fine against Qualcomm for antitrust violation in terms of its licensing practice. So, what has Qualcomm done so far to change its licensing strategy and methodology so that to avoid potential antitrust violation issues down the road?
Okay, that's not an easy one. Thank you for asking. So I think it was like 1.5 years ago regarding China, so we had to comply with the decision. I can tell you that since we complied, it was easier for us to be able to receive royalties. I remember just before the decision, if I'm not mistaken, we had to report that we were not able to collect royalties in China for many, many, many players. And I think that the stock price dropped to like 25 or 30%. Don't quote me on that because I don't remember exactly. It's a struggle. Because at one time, we want to be the best on the market as a technology. I mentioned to you 75% are engineers. There was a question before on how you can incentivize people, to respect IP. I don't have the answer, but I can tell you that at Qualcomm HQ, we've got the patent wall with the name of employees, and they're kind of competing. So we strive for the best technology, and sometimes we are the best. And so when you are the best, of course, you have antitrust asking question. We are discussing with, as you mentioned, many antitrust authorities across the world. We are doing our best to respect all the rules. This is what I can just answer you. But I can tell you that it's always better when it's over. And now we have more and more licensing discussion with China because in the wireless industry, this is where the market is right now and taking up a lot. I hope I was able to answer your question.
Some other questions?
Another one, yeah. So I left the communication industry a few years ago. So back in the times when I was there, raising your hand during the standardization meant that you sent in a blanket statement saying, I have patents. It seemed that, is it not loud enough?
No, I didn't get, I said
So it was just a blanket statement. So you said, yeah, I have patents on that standard and I'm prepared to license them for FRAND terms. And then some people started to not just have those blanket forms, but put in like 1,000 patents they had or a list of 100 patents. You said it's raising your hand today and really saying something. I mean, has really something changed, or is it still the way that they're just saying I have patents?
So I can tell you what the engineers are telling me, okay? So it's more or less like you raise your hand, or you fill out the form, okay? You cannot just say, I've got 1,000 patents, because if you say that, you're going to scare everybody and nobody's going to continue to develop because there is no point. It is true that in the ICT industry, we have a lot of patents. And it is true that we all need to work together to bring more transparency and clarity. How are we going to do that? That's a good question. I think, as I said, we all need to work together to improve the system. I'm not saying the system is absolutely perfect. It is true that there are some things that we need to improve, and the number of patents, of course, it is. But what can you know, I used to work for another company before Qualcomm, a smartphone vendor, and the CEO used to say that, in fact, the technology is much more complex in a smartphone, and it was 5 years ago already, than sending someone to the moon. So the technology is complex, it's just a fact. You know, it's not like you're going to have one patent. Like in the pharma sector, you can have one patent and you have one product or even one success story. It's just not like that in our industry. How we're going to make that evolve, I think we all need to work together to see how we're going to evolve that. But it's true that for new players in the industry, it's a bit scary.
So do you see a push that the engineers and maybe your policy departments are saying, let's really discuss it during standardization? And not, because usually it's good to have the dispute up front, to really discuss there, what's the patent, what does it matter?
To declare you have a standard essential patent?
No, you should really have the discussion then. So I mean, the way it really works, doesn't it, is that you're sitting there, you file the patent one day in advance, and you're not really telling people, not saying that Qualcomm is doing it, but other people are doing it. And then 5 years, 10 years later, we are discussing at the courts what should be the FRAND term. And I wonder, why don't we do it really ex ante and speak with each other there when the engineers sit together at the table and say, do we really put that in the standard or don't we?
Well, you know, I mentioned some of the valuation methodology, but I think that very likely for the future, some people in the industry might go that way. That's why I mentioned the ex ante with a company, you know, decided to publish the fund rate. But what I hear now that, it's too low, it's too high, so people will always complain. It's just like, what I think for companies and for the industry, they need to think of what is best for them. For the telecom sector, what is best is to enable others to do. So if you don't have the right price, there will be no market. So you can take it differently. And that's why I had the 2 other slides just to show the evolution of technology. You can hear like many people complaining about the price, about the case, about many, many things. But if you go back 10 years ago, 15 years ago, and you see the evolution, I'm happy to. Because I'm not an engineer, so in the megabit, I'm not very good. But if you see the leap of technology between the 80s, until 2010, and it has improved a lot. This is absolutely massive. Absolutely massive. And at the same time, if you take any smartphone, you see that the prices are dropping very, very fast at the same time. So anyone needs to find the return at some point. But technology is in big evolution. There is value creation for everybody, and prices are dropping very down. So, and more market entrant players. So to me, it's a sign that not everything is bad in this market. You know, we are all enjoying our technology in our pocket. But it's true that there are some work to be done.
Thank you.
Thank you.
Some more questions to the SCPs?
Not a question, but a follow-up on that one. I think it suffices to look in the ITU, ETSI, and IIPLA declaration databases to see that the number of declarations is much lower, I think, than the amount of work put in standardization. So I don't think for a lot of companies that much has changed. There's still, I think, a lot of work going on where it's assumed that if you make a technical proposal, you assured patent rights behind it. And the ex ante is very difficult, because if you filed the day before your patent application, you really do not know what the end result will be, what your granted patent will be. what in the end will be incorporated into the standard. So defining a rate upfront. I find Ericsson very courageous, but they're also a big contributor to 5G, so I think they had a different kind of business model than a patent per patent FRAND rate. But yeah, I think that the official rules are not applied in a lot of those consortia in reality.